Swayam Prabha. Digital India. Educated India.
The Patents Act have certain miscellaneous provisions. Miscellaneous provisions are provisions that do not fit into any of the earlier chapters. So, they had to be collected in a separate chapter. So, you will find chapter 23 which deals with miscellaneous provisions. There are a wide variety of things that are collected under this chapter. We will quickly take you through the gist of these provisions so that you know what these provisions are, but they do not require a separate treatment in the sense that they are not parts of the prosecution process. They are not things that normally happen during the prosecution process. Even if they are of a supplemental nature. That is the reason they figure in a separate chapter under the heading miscellaneous. Now, section 140 deals with avoidance of certain restrictive conditions. Now, when you enter into a contract pertaining to a patent, you cannot have certain restrictive conditions, and some of the, especially in a license, not so much in a sale or a lease, because a sale can be a conclusive sale of your rights, but we see this occur in cases of patent licensing. Now, what are those? Some of the instances are mentioned here. You cannot provide a provision for exclusive grant back in D here, prevention of validity to challenges to validity of a patent, coercive package licensing. If you have any such term in your agreement of licensing or sale or lease of your patent, then such condition shall be void. Restrictive conditions are conditions which, when a person is dealing with patents, when a person is licensing, most of the time it appears in cases of licensing. As licensing is patent, he cannot have certain restrictive conditions. For instance, a patentee cannot tell the licensee not to challenge the validity of his patent. So, validity challenges, filing post grant opposition challenges, filing revocation petitions, these are rights, statutory rights that are given to any licensee. So, just because a person is in a license arrangement, you cannot force him to give up these rights. So, prevention to challenges to a validity of a patent, even if there is a clause to that effect, the courts, if they are called to look upon it, they will treat that condition as a void condition. It will be null and void, it will not be given effect to. Coercive package licensing is where the patentee has certain patented products, he also has certain non-patented products which are not covered by a patent. He would want the licensee to take the patented and the non-patented products together as a package. So, package licensing is where patents that there are patented as well as non-patented products. So, if there is an agreement even to take non-patented products or technology or invention, then that condition will be void. The reason being, what is non-patented is not protected, and a person is free to use it if the person gets it through a legitimate channel. So, unless it is a confidential information or a trade secret, but if it is something the technology is non-patented, the understanding is that anybody else should be free to use it. So, when a patentee combines patented and non-patented products in one agreement and forces the licensee to take it, that condition of clubbing, or what is used by the Act, coercive package licensing, will be void. Now, 141 deals with a provision where certain contracts, like a contract for a sale or lease of a patented article, or a license to manufacture, use or work of a patented article, or relating to any such sale, lease or license, may at any time after the patent or all the patents by which the article or process was protected at the time of making of the contract has or have ceased to be in force, and notwithstanding anything to the contrary in the contract, be determined by the purchaser, licensee, etc. of the patent on giving 3 months notice in writing to the other party. Now, this simply says that if you undertake a license of a patent, when the patent expires, you can issue notice giving 3 months notice to the other party, the patentee, and terminate the contract, because the contract survives based on the patent. So, if the patent has expired, then there is no need to honor that contract. It is open for a licensee to give notice of 3 months, giving 3 months notice in writing, and to terminate the contract. 142 deals with fees. Section 143 deals with restriction upon publication of specification. This provision states that there is a normal 18-month period during which an application is kept unpublished, unless the applicant requests for a publication. This provision states that the application shall not be published by the controller before the expiration of the 18-month period, or before the same is open to the public inspection in respect of the conditions mentioned in 11A3, and which is the 3 conditions where there is a secrecy direction passed, or the patent application, which is a provisional, is abandoned, or it is withdrawn, or the patent itself is granted under 43. So, these are the conditions in which the patent can be published. 144 states that the reports of the examiners to be confidential. Now, these reports are different from the report what is referred to as the first examination report or the first statement of objection. This is a report that moves from the examiner to the controller. So, this should not be confused with the first examination report or the first statement of objection. So, this report shall be confidential unless it is required to be produced by the order of a court. The Patent Office has a journal. 145 refers to the publication of the official journal, and it is published every week. The applications that are published are notified in it. The grants are also notified, and if there is any amendment to a patent, amendments are also published. So, this is the official journal, and it is available at the Patent Office website. A soft copy is available. Now, 146 deals with the power of the controller to call information from patentees. The controller has the power. There is a provision where the patentee has to file working statements using Form 27. Working statement requires the patentee to disclose to the Patent Office whether the invention is being worked, or if it is not being worked, the reasons why the patent is not being worked. Now, these are statements, timely statements, which has to be filed before the Patent Office using Form 27. Now, if a person fails to file, or regardless of whether a person has been filing this or not, the Patent Office can on its own ask for this information. So, 146 deals with the responsibility of the patentee to file at regular intervals information pertaining to the working of patents. It also covers the power of the controller to call for these information whenever the controller deems fit. 147 deals with evidences of entries, documents, etc. And we had seen that the Patent Office keeps a register, and a copy of the register will be regarded as evidence of an entry in the register. Now, 148 deals with declaration by infant, lunatic, etc. Now, in law, an infant or a lunatic or a person of unsound mind cannot enter into a contract. There is a legal disability, and that is factored here. If any person is by reason of minority, lunacy or disability incapable of making any statement or doing anything required or permitted by or under this act, the lawful guardian, committee or manager can do it on his behalf. These provisions exist in different laws, so that's been incorporated in the Patents Act too. 149 deals with service of notices, etc. by post. 150 deals with security for costs. In some cases, the controller can insist on security for costs if the person is not residing in India or carries on business in India. If the person is not in India or does not carry business in India, then the controller can insist on a security of costs. Now 151 deals with how the orders passed by the High Court and the Appellate Board can be transmitted to the controller. And 153 broadly deals with information relating to patents. The corresponding rule is Rule 134, where a person can approach the patent office for information relating to patents. There is a procedure to do that, and all the information that is meant to be public, like we saw that after the publication of a patent application, you can get copies of the complete specification and other documents. So those documents can be obtained, or information pertaining to those documents can be obtained from the patent office by payment of a required fee. 154 deals with loss or destruction of patents. If patents, by loss or destruction, we talk about the patent certificate. You could ask for a duplicate, it's provided for. Now reports of the controller to be placed before Parliament. 155 deals with that. 156 says that the patent binds the government. So the government grants the patent, but it is also binding on the government. And 157 deals with the right of the government to sell or use forfeited articles. Patents, the articles that are forfeited, which could be patented, can be sold by the government. Now 157A deals with protection of security of India. What can be done if certain matters affect the security of India, if it is disclosed in a patent application. We already saw that there are provisions where secrecy directions can be issued. Now, notwithstanding anything contained in this Act, the central government shall not disclose any information relating to any patentable invention or application relating to the grant of a patent under this Act, which is considered prejudicial to the interest of the security of India, or take any action including revocation of patent which it considered necessary in the interest of security of India by notification in the official gazette. Now what pertains to security of India, you will find that something that affects war and emergency in international relations, relates to traffic in arms, ammunition, fissionable material. All these things are broadly classified as atomic energy, as section 4 tells us, will be regarded as things that pertain to the security of India. The High Court has the power to make rules, and respective High Court do make rules when it comes to patent proceedings, and the central government also has power to make rules, and which is what we have seen in the form of the Patent Rules 2003. And the various matters under which the central government can make rules are mentioned therein. The rules, when they are made, have to be placed before the Parliament. 160 deals with that, and 162 deals with the repeal of the earlier Act. We had already mentioned the Act of 1911 was replaced by the 1970 Act. So the 1970 Act has a provision which expressly states that the earlier Act is repealed. Just as we saw, there are some miscellaneous provisions in the rules as well, and they are a bunch of different things, and it will make sense when they are read in the context. So you can see the cross references here. 121 deals with the period within which copies of the specification are to be filed, address to communication, correction of clerical errors, manner of advertisement of proposed correction. These are largely procedural matters. Manner and time of opposition of making of correction. If there is a correction that has to be done, then that also can be a subject matter of opposition. Notification of corrections, form of affidavits, if they are filed in India, how it is to be done. If they are filed in a country or sworn in a country outside India, then you have to go to the as per the Diplomatic and Consular Offices Oaths and Fees Act. It has to be complied. They have to be apostilled. There is a process for doing that. Now exhibits, 127 deals with exhibits and how to deal with them, and 128 deals with directions where there is no provision provided for. 129 deals with the discretionary power of the controller. So wherever the controller exercises his discretionary power, which could prejudice the party, the controller has to offer a hearing. So this is a provision which mandates hearing of a party whose rights could be affected when the controller exercises his discretion. So, if it is a normal thing where the controller does not have a discretion, for instance, the controller receives the report of the examiner, the confidential report, the controller has to issue a first examination report or a first statement of objection. There is no discretion there, he has to do it. Whereas a controller, after hearing a post grant opposition, has a discretion either to reject the patent or call for an amendment or to uphold the patent. So, in whatever he does, he would be exercising his discretion. So, when he exercises his discretion, if it affects a party, the party is entitled to a hearing. Hearings can be adjourned. There is a provision for adjourning hearings, and there are some requirements of notice, and the controller can review his own orders. So, 130 deals with review of decisions and setting aside orders of the controller. Now, we had seen that Form 27 requires working statements to be filed, and Section 146 gives the power the controller to ask for some information with regard to working of patents. 131 deals with the procedural aspects. Now, 132 deals with the form to be used while getting a duplicate patent if your patent is destroyed. So, these are all supplemental provisions which pertain to certain aspects of patent prosecution. Supply of certified copies, request for information. We saw that under 153, section 153, you could make a request for certain information. Now, how that is to be made and the details are given here. Now, the patent agent, you can appoint a patent agent who acts as an agent of the patent applicant by filing Form 26. By the form you authorize a person to act as an agent. 135 deals with that. The controller has the power to award costs. The scale of costs or the amount of costs can be determined in accordance with Rule 63. Now, the controller has the power to do that. Powers of the controller generally, where there is no provision to amend a document, then the controller may, in the interest of the parties involved, correct the document. So, there is a power generally given to carry out changes in a document where there is no specific provision. The controller has the power to extend time. There are some limitations. 138 rule 138 deals with that. Now, hearing before the controller is normally a public hearing unless the controller directs otherwise.